Good afternoon, and welcome to our weekly webinar series on coronavirus updates. Once again, I'd like to say welcome to all our clients and our friends. My name is Pete Jones. I'm a partner in our Syracuse, New York office. Before we get started, I'd once again like to offer a word of encouragement to everyone. This crisis is trying. The things that we're being faced with are unusual. The word's overused, but it's absolutely correct. It's unprecedented. In my experience, our clients and our friends are handling this very well under very trying circumstances. So I'd like to just give everyone a little shout out and a boost here before we get started. Today we've got a varied set of topics. We're going to start off with layoffs and furloughs and WARN Act issues, just a brief update, and some things to think about from Mary Aldridge in our Buffalo office. And then we're going to talk, have some words from Katie Anderson, Adam Masterleo, and Dan Pouts, different aspects of reopening. And we may be a little bit away in terms of time from reopening, but we think it's probably time to start thinking and planning ahead so that you're ahead of the game when the time does come. So we'll have some updates on that, and then at the end of our program today, we're going to have a few words from Jeff Shear on loan issues, the payroll protection program, kind of the old, the new, and what's happening on that front. So with that, let's start. Mary Aldridge in our Buffalo office. She's in our labor and employment group, and she's going to talk a little bit about these issues that continue to we continue to struggle with. WARN Act notices, layoffs, furloughs. Mary, take it away.
All right, thanks, Pete. So today I'm going to give a brief refresher on the WARN Acts in a general sense. And then more specifically, I'm going to discuss employer obligations when group layoffs are extended longer than originally anticipated. And then I'll briefly discuss part of Executive Order 202.19 that came out on Friday. So as a high-level overview, WARN is a notice statute. It basically says, hey, employers, if you're implementing a closing or a layoff that employees this to the affected employees, a federal WARN statute that of course applies throughout the country, and relevant to most of you is there is also a New York State mini WARN Act that imposes additional requirements for employers in New York State. In New York, the notice period for most situations is 90 days in advance of the plant closing or mass layoff. All right, next slide. So the first step in a WARN analysis is determining if the statutes even apply to you. If you have less than 50 employees, then WARN does not apply to you, and that's one less thing that you have to worry about. However, if you have more than 50 employees, then New York WARN applies to you, and if you have more than 100 employees, then both New York and federal WARN apply to you. Let's exclude part-time employees as that term is defined in the statutes. Next slide. So assuming that the statutes apply to the event takes place, there are two main types of triggering events. One is a plant closing and the other is a mass layoff. Under New York WARN, a plant closing is a permanent or temporary shutdown of a single site of employment if the shutdown results in an employment loss of 25 or more employees during any 30-day period. A mass layoff is a reduction in force at a single site of employment during any 30-day period for either 25 employees constituting a third of the employees at that site, or at least 250 employees, regardless of the percentage. These counts, again, exclude part-time employees, and the thresholds are higher under federal WARN as slide. Importantly, under both statutes, only triggered if the employees are out of work for 6 months or more. A temporary layoff of less than 6 months is not a WARN triggering event, and notice is not required at all. Next slide, please. Okay, so based on what I just discussed, you might be thinking, okay, We expect our layoffs to be shorter than 6 months, which means we do not have any warrant obligation, necessarily off the hook forever. Now, of course, we are all hopeful that the COVID-19 crisis subsides quickly. However, the unfortunate reality is that the impact on some businesses is cutting deeper than anyone originally anticipated. So as an employer, you might start thinking, well, those layoffs that we already implemented, we did not give warn notices because at that time, we honestly thought that the employees were only going to be out for a few weeks or maybe a couple of months, but not for 6 months. But now we're not so sure. Our circumstances have worsened since then, and we might not be able to bring people back in less than 6 months. I imagine this is a dialogue that's familiar to many of you right now. In this situation, your warn obligations have resurfaced. Under the New York State warn regulations, an employer that previously announced and carried out a short-term layoff of 6 months or less, which is being extended beyond 6 months due to business circumstances not reasonably foreseeable at the time of the initial layoff, must give notice as soon as it becomes reasonably foreseeable that an extension is required. This means that you must give notice when it is foreseeable that previously implemented layoffs will extend beyond 6 months or will ultimately be permanent. The key is that you must be able to explain how your business's circumstances are different now than they were at the time of the layoff. For example, say you're an event center, you implemented temporary layoffs, and then subsequently most of your upcoming events for the next year or so have been unexpectedly canceled. At the time of the layoff, the extension may have been unforeseeable because your events were still scheduled at that point. But now it might be foreseeable that the laid off employees won't have work to do for longer than 6 months due to the recent cancellations. This is the type of thing that you'll need to be able to explain. If you need any assistance with either determining whether you have warrant obligations or with drafting the notices themselves, please reach out to me or another bond attorney, and we are happy to help you with that. Next slide, please. Okay, so on a slightly different note, Governor Cuomo's recent executive order, which is number 202.19, contains a paragraph that discusses an interplay between the Paycheck Protection Program and New York Labor Law Section 860-B, which is New York's warn statute. As many of you know, loans issued under the PPP are only forgivable rent, utilities, etc. during the 8-week period immediately following the initial disbursement of the funding. The relevant text of the executive order is up on the slide, and as you can see, this provision is far from clear on its face. We don't know for sure, but this provision could be addressing the unique situation of an employer bringing back furloughed employees only during the period where it's using PPP funding. More specifically, this provision could address warn compliance in the following situation. The employer initially furloughs employees, then receives PPP funding, and only brings back the employees for the 8-week period and then re-furloughs them. Under the executive order, warn compliance would only require that the employer gave notice at the time of the initial layoff. Please note that this is only a preliminary interpretation based on the text of the executive order, and it's not definitive at this point. We are hoping to receive more or further interpretation on what this provision means, and we'll keep you updated as additional information becomes available on that. So that is all I have, so I will toss it back to Pete Jones. Thanks.
Thanks, Mary. Difficult questions, I think. A lot of employers we know are grappling with furloughs, which, for lack of a better word, would be temporary layoffs. Layoffs, which connote, I think, a more permanent separation from the workforce, and the WARN Act obligations under the collective bargaining agreements, all those sorts of things. A tricky area, and an area that I think, in light of the way the crisis is evolving, the answers are evolving as well. Okay, let's turn to Katie Anderson. Katie has been following our developments from Albany tirelessly here for the last month and a half, and it's basically a weekly segment, the update from Albany with the latest things from the governor's executive orders and any other observations. Katie, take it away.
All right, yeah, time for my weekly segment now. Katie's Corner, we should call it. Just throwing that out there, Pete. So looking at the executive orders from the past week, it's been another dizzying week in New York. You've had 5 different executive orders issued. We're going to talk about a few of them, but I'm just throwing those out there so that you know that the way that you feel right now, which is probably, spun out and dizzy as well, that is what's happening on every level of government. So if we could go to the next slide. We're going to look at face coverings and masks. This was a topic that we had last week, and 2 of the executive orders that were issued are about wearing face coverings in public. And then immediately after we finished our webinar last week, the Department of Health issued guidance on what it means to wear a face covering at work. The Executive Order 202.16 is about employees with direct contact with the public have to wear face coverings. And so what then is a face covering? According to the Department of Health guidance, it's their cloth, bandana, surgical masks, N95. Employers have to pay for those face coverings for their employees. An employee can bring a face mask from home, but that face mask, the employer can't require the employee to bring that mask. If we could go to the next slide, please. Another question that has come up a lot is, what does it mean, you have to provide these face coverings to employees who have direct contact with the public? What does it mean to have direct contact with the public? So the Department of Health really kicks that question to employers. Employers are the ones who have to determine which employees have direct contact with the public. Minimally, it means that you are routinely in close contact, as in within 6 feet of members of the public. So think about, a grocery store clerk. That is somebody who is absolutely, interacting with the public on a regular basis. So these are the types of things that you're going to have to be thinking about going forward. And we're going to, the second half of what I'll be talking about today will be discussing going forward in New York. But masks and face coverings are really going to be, that's what we are all going to be having to wear until a vaccine is available. Let's keep going forward. Thank you. If an employee refuses to wear a face covering, this question has been a big one. It's come up a lot. And just remember, that the employer, does have the duty to determine whether the employee's condition can be reasonably accommodated if it is due to a medical condition that they are not going to wear a face covering. This may include reassigning the employee to duties that don't include interaction with the public, but this is something that is very, very fact specific. This is something I, really encourage you, if you have questions about it, please reach out to, any of us after, because this is one of those situations where we will necessarily need to know confidential information in order to answer that question. If we could get the next slide too, that would be great. So now we're going to turn to looking at the new executive orders that have, you have to wear a face mask in public if you are unable or not maintaining social distance. Notably, this slide lays out everyone who has to wear those face masks. You are 2 years and older, and you're medically able to tolerate a face covering. The face covering has to cover your nose and your mouth. I was going to get a bunch of face masks up here and show you, but everyone's seen them at this point. You don't need my demonstration. When you're in a public place and unable to maintain social distance. So that means, if you are on a walk in a park and that park is not very crowded, you don't need to have that face mask on unless you are within 6 feet of another person that you are basically not on lockdown with. a person who's not a member of your household. So, keep a scarf around your neck, keep a mask around your neck, pull it up when you need to. When you go into a grocery store, wear that. Notably, there are no penalties for individuals who don't follow this. They haven't included those enforcement measures yet. That's not to say that New York State won't tack that on there in the future if there's not compliance, but those penalties don't exist at this point. And, let's turning to what it means to be going forward. If we could get the next slide. So this grid, this was taken from one of the governor's press conferences. It was the conference that he held last Thursday. He had this grid out, and one of the things that he has been focusing on lately is how are we going to reopen? What is New York going to look like, and what do we have to do in order to reopen? Today, he announced that we are going to really be looking at a regional approach. So the southern tier, for example, may open up very well before, Long Island, and so on and so forth. So really start thinking about where you are in New York and what you can do. So if you look at this grid, you see that if you have a low infection risk and you're a more essential industry, you're in the green grid. So that indicates that your business would be likely to open up sooner, rather than one who's in the yellow or especially the red. So the question becomes, it's hard to calibrate the essentialness of your business, but what you can calibrate is lowering the infection risk. And in order to do that, really start thinking and perhaps developing a plan that, at some point this may need to be submitted to the state, but start thinking through these problems, start thinking through workplace precautions, how you're going to implement social distancing, start thinking about customer interaction and, what you will be doing to limit the number of people that enter your facility. Start thinking about your proactive infection plan, right? If somebody at your workplace is infected with COVID, what are you going to do at that point? Those are, that is going to be really crucial to start thinking about and mulling over how you're going to be doing that. This is, again, this is all just speculation at this point based on what the governor has said so far. But we think that this is, pretty much on the pulse of where he is going with how the economy will reopen. In the chat, I'm about to put a link to an information memo that we published today that goes into more detail on what we think New York Forward will look like. So, after this, feel free to take a look at that. And if anybody has any questions, feel free to reach out. But I know that Adam is now going to take it away, looking at what we should be doing going forward as well.
Hey, Katie, before we move on to Adam, just real quick, and this is more of an observation, but some of the things that we have talked about repeatedly over the last several weeks are specifically in the executive orders. And some of the things have been mentioned by the governor in his press conferences. This slide that you've put up is not in an executive order, correct? It's the kind of thing that gives us, I think, a sense of where we're headed.
Exactly. This is not an official policy at this point.
Right. And then we've had other things that have, kind of had the Matilda's Law might be a good example, which is, I think, more of a statement of best practices rather than either guidance or an indication of where we're headed. That
is correct. That is, Matilda's Law is different in that it would be, it's the state trying to come up with how we would be restricted and thinking about restrictions. This is, a thought process of how are we going to open back up? And those, it's not official. It's These are just the musings of the governor and our interpretation of them. But he has repeatedly, over the past week now, said that we are going to have to calibrate businesses. Businesses will have to rethink how they do business. Businesses will have to think about how close people can be to each other, and all of those things. So it's not, this is not an executive order at this point. Maybe something will be out on this by next week, maybe not. But either way, really start thinking about these issues. We think that this is where things will be going.
And that, I think, is a great segue to Adam's piece, because I know Adam's given this some thought and tried to put a little bit of organization around the framework suggested by the governor, and also the reopening plan or program that's been introduced at the federal level. So Adam, take it away.
Thank you, Pete. First of all, let me just say that I'm happy we're at the point where we're talking about reopening, and we're talking about how we're going to reopen the state and the country. Unfortunately, reopening is going to present an entirely new set of issues. We are reopening in a world with new challenges, particularly for employers. This is a different environment. Reopening, we should anticipate, will be gradual. It's highly unlikely that businesses are going to go from totally closed to totally open. And because of this, businesses are going to have to put in place new policies, new plans for a couple of different reasons. One, because it's the right thing to do and we want to protect our employees and our customers, but also because it's pretty clear that complying with federal and state requirements is going to be part of the reopening process. Now, as Katie just talked about, the governor on last Thursday put forward his plan to, quote, unpause New York. And part of that plan discussed how we're going to reopen and the factors that he is going to consider and the state is going to consider in reopening. So when we look at this grid, we see that your level of essentialness and then your likelihood of spreading the infection are going to be the two factors that are considered in how quickly you get to reopen. With respect to essentialness, we don't know specifically how that is going to be determined, but we can work off of our current experience. Right now, there are essential and there are non-essential businesses. The state chose to use lists to decide what's essential and what's not essential. They may decide to do that again with reopening. And we've seen how that has worked. Unfortunately, it hasn't been the smoothest process. We've seen businesses like the construction industry that were initially deemed to be essential, and then there were some significant restrictions put on that in a later executive order. So we have to really make sure that we're keeping an eye on how the state is defining what is more essential versus less essential. Now, depending on the type of business that you have, you might not have a lot of wiggle room with the essential determination. You might just be a non-essential business. So you can't really impact your ability to reopen on that basis. But what you can do is take steps to limit and mitigate against the spread of the infection. And we'll talk about that next. How businesses are going to be categorized with respect to the spread, likelihood of spread is also up in the air. We don't know if the state is going to use a list type approach, but we know that any business that wants to reopen is going to have to perform a risk analysis and do what it can to reduce the likelihood of spread. And I'm going to talk about that in a minute. So we know in New York that reopening is going to be based on this analysis between level of essentialness and risk of spreading the infection. The federal guidelines, if you could switch, Kathy, the federal guidelines, they don't discuss the essential and level of risk of infection analysis, but what they do include are some policies for all employers that they're going to look for or they're recommending employers adopt. Governor Cuomo's plan to unpause included all of, if not some additional policies that employers are going to have to include. So for example, employers are going to have a plan that deals with workplace safety. Are there social distancing measures that employers can put in? Can you utilize telecommunication? Do you have to adopt sanitization procedures and policies? Are you going to be checking employees for temperatures or screening them in some way? Are you going to be limiting business travel, closing common areas, etc.? So these are all things that both the federal government and the state government have said they're going to be looking for as part of any reopening plan. We don't know what that process is going to look like. We don't know if this is going to be an application that you might have to submit to the state government. We will obviously keep an eye on that. But what I want to transition to now is, what can we do now? What can employers do now to prepare and to be ready for this transition? Before I get started discussing some of the things, I just want to make sure to point out that this is a very fact-specific and industry-specific analysis. While the policies that you might implement have common topics, they will be very, very specific to industry and employer. For example, a manufacturing employer is going to be implementing a very different work safety plan than an office space. So these are things that you're really going to have to work through and think through specifically to your business. Now, some of the things we can do. Number one, you can conduct an analysis specific to your workplace and develop and document plans to address and minimize risk, which will include policies relating to workplace safety. So employers will have to ask themselves, how do employees at my workplace come into contact with one another? Are they on workplace? Are they on the factory floor? Are they interacting in offices? Are they sitting in cubicles? And the answer to that question will drive how you work to mitigate the risk. So, for example, can you limit contact through actions such as staggering shifts? So if you're an office space and you generally operate 8:30 to 5 o'clock and you have everybody there during those hours, does it make sense for you to stagger shifts in some way so you have less people in the office? If you have cubicles, do you need to separate them, or can you separate them to an acceptable distance to reduce the likelihood of spread? Do you need to limit access to or close common areas? If you have a kitchen area at your facility, do you need to close that for the time being? Are you going to screen employees when they get to work? This is a question that would have been potentially laughed at 6 months ago, but now it's a reality. Are we going to, as employers, take temperatures, conduct any screening when employees get to work? Is that feasible? Do employers need to provide protective personal equipment? Can you? Are you in an industry where that makes sense? Are you going to provide training to employees regarding hygiene? Any workplace safety plan is going to answer all of these questions and probably some more. In addition to developing a workplace safety plan, employers can also develop plans that are designed to address the various stages of reopening. So for example, if you're reopening at 50% or 25%, the precautions that you put in place may be different than precautions that you put in place when you're at 100%. You can work with your attorney to develop these plans in a way that complies with all the legal requirements and they're designed to keep your facility safe. You can also review your existing PTO and leave policies. You can prepare plans that address sick employees. How are you going to respond? And if an employee tests positive for COVID, when are you going to allow them to return to work? Are you going to check in on them? All these types of things are questions that you need to answer. So putting these plans together now is crucial because you will be able to anticipate any guidance that we get from the government, and you'll be able to reopen quicker. And that is obviously the goal here, to get everyone to reopen as quickly and as safely as possible.
Adam, thanks. I want to just briefly go back to something you said a couple minutes ago, because I think it bears repeating, and that is, there's not much we can do about the essential nature of our businesses. They are what they are, in terms of, where they fall in that designation. But there is a lot we can do with respect to the risk piece. And that's really what you're talking about here, are ways to get ourselves ready, to minimize those risks and move us from red to yellow or yellow to green. Try and get us to a place where we're able to open quicker in a safe and acceptable fashion.
Exactly.
The other thing that I think you said that's important to emphasize is the idea that we can do this now. I'm reminded a little bit of the, essential business applications to the Empire State Development Corporation, and that, some people weren't ready for that. How could they be? They didn't know what would be in the executive orders or what the process would be. But it seems to me that, we do have a preview now of what this looks like on the state and federal side, and we can start to get ready. Okay, to shift gears a little bit, I want to turn it over to Dan Pouts. Dan is a litigator in our Syracuse office, and he's got another aspect of being open or reopening for people to think about, and that is some of the negligence and litigation issues. Dan, take it away.
Thanks, Pete. I appreciate the opportunity for a couple of minutes. As Pete mentioned, I'm a trial attorney here in Syracuse, and obviously, none of us ever want to think about being involved in a lawsuit. It's not something that we want to think about or look forward to, but it is something that particularly now we should think about, at least in terms of preparing or trying to mitigate against the risk of being sued. The fact of the matter is there hasn't been a lot of lawsuits filed yet with respect to COVID-19 related issues, but primarily that's because the court system, both on the state and federal level, has largely been closed. But if history is any indication, every time there's a significant disruption of our lives, whether that be the housing collapse or natural disasters or things like that, litigation on a variety of issues is certain to follow, and we think that's going to be the case here. One specific claim, as Pete mentioned, that we anticipate is negligence claims that are brought against businesses, both by patrons of that business and employees of that business. And those two types of claims are different. And as I mentioned later, we're going to analyze them differently. But in terms of negligence, we've all heard the term negligence. And basically the definition is very simple. It just means failing to act as a reasonably prudent person would have acted under the same circumstances. And by definition, it's a very fact-intensive analysis depending on the specific circumstances. The first step in determining what a reasonably prudent person would do is figuring out the standard of care. And the standard of care is quite simply, what would a reasonable person have done in these situations? And if a business's actions or inactions fall below what that applicable standard of care is, they could be deemed negligent. So figuring out what the standard of care is, particularly now, depending on your business under these circumstances, it's very difficult. There are certain times where figuring out or analyzing what the appropriate standard of care is and whether or not that was complied with is simple. An example that I use often is in a motor vehicle accident. If somebody's driving 120 miles an hour in a 55 mile an hour zone, most reasonable people would agree that that person fell below the appropriate standard of care. But other times, as I mentioned, especially now, it's difficult. It's difficult to figure out what is our obligation, what is our duty, what is our standard of care. Generally speaking, as business owners, what we need to do is we have a duty to take reasonable measures to limit both our patrons and our employees' exposure to dangerous conditions. What does that mean? Well, it means that you have to maintain your premises in a safe condition and avoid conditions that could render the premises unsafe. Now, as Katie and Adam both mentioned, there's been a significant amount of guidance that comes out and has continued to come out, and it's constantly evolving by the hour, by the day, and certainly by the week. And this guidance tells us, for lack of better words, the rules of the road. For example, Governor Cuomo recently ordered that essential businesses are required to maintain and enforce social distancing measures. That includes the mandate that Katie mentioned earlier about the protective masks. And we've heard some anecdotal evidence of businesses being shut down by local health departments because of their failure to follow and comply with the social distancing requirements. It's very, very important in analyzing what our standard of care is we must look at these and be mindful of the guidance that's coming out, both on a local, state, and a federal level, because that is what's going to establish, ultimately, we believe, the standard of care. In other words, if business A is doing something in order to protect and maintain the safety of their the condition of their premises, and business B is not, we believe that business A, in compliance with the local and state and federal guidance, they're going to be establishing the standard of care, and it's incumbent upon everybody to comply with that standard. Now, certainly, like any litigation, there's going to be a number of defenses available in negligence claims. Obviously, these haven't been litigated yet, but generally speaking, we think it could potentially be difficult to prove exposure. The date, time, and place of when somebody was exposed to this virus, it may be difficult attributing it to a specific business at a specific time. The other defenses that we believe may be available is there's been a tremendous amount of published information with respect to what people should do. So if people want to go out and patronize these businesses, there could be a certain amount of contributory negligence attributed to a person if they don't themselves comply with the social distancing mandates that all of us by now are very well aware of. And those are just two examples. We think that as this develops, there's going to be a significant amount of additional defenses that may be available that we're certainly willing to talk through with you, depending on your circumstances. Additionally, as I mentioned before, dealing with patrons is different than dealing with employees. Certainly as a business, we also have an obligation to maintain safe premises for our employees. For example, the New York State Department of Health and the CDC have both come out with guidelines and directives for maintaining a clean and safe work environment. You need to be mindful of those. You need to be aware of those. And as Adam mentioned, you need to be willing and able to quickly implement those and enforce whatever guidelines there are. One important distinction when dealing with employees, and this goes to the defense issue that I talked about before, is as many of you may know, if an employee alleges to have been exposed to the virus while at their place of employment, that's likely to fall under the purview of workers' compensation insurance. And generally speaking, under New York law, workers' comp benefits, that's the employee's sole legal remedy for an injury that occurs on the job. And again, there will be other unique defenses when dealing with potential claims brought by employees. But the takeaway here, folks, is that unfortunately, as much as I'd like to tell you, it's not the case. There is no magic formula to avoid these types of claims. Litigation happens, lawsuits happen. The most important thing that you can do is stay informed, document everything, and continue to modify and evolve your operation to comply with the best practices, as Adam mentioned earlier. Then, of course, in the unfortunate event that you do receive a demand letter or a copy of a summons and complaint, it's very important that you contact us immediately and we can start to work through what, if any, defenses are available to you. So I thank you again for the time, and everybody please continue to stay safe.
Thanks, Dan. Before we move to Jeff, I just want to clarify real quick, because there's been a handful of questions on this, and I think it's natural. Where we are right now is we've got the pause executive orders that basically shut down in-person operations subject to the essential business requirements, the requirement that people work remotely to the extent possible, and folks who support essential businesses being essential to the extent that they do. When we put up that graphic about New York Forward, we're talking about non-essential businesses or non-essential parts of essential businesses being allowed to reopen. And that's where we're talking about mitigating the risk so that A, you have the ability to reopen and that you can do so safely without, without the consequences of, having to go back to extreme shutdown and social distancing. So it is a little confusing because the graphic indicates your level of essentialness or your non-essentialness. And so what it really is talking about is as we go from only essential business operations to allowing others to operate, what's our plan for mitigating that risk and making sure that we can do so safely? Just wanted to clarify that because there were a handful of questions. Let's move on to Jeff Shear. Jeff is a partner in our Syracuse office, business background, healthcare background, and he has been closely tracking the relief program. So Jeff, take it away.
Thanks a lot, Pete. Glad to be here again. I'm going to jump right into this and hopefully finish before the guy starts mowing my lawn and interrupting me. So here we go. So the question I've been getting asked a lot is, I have my paycheck loan, what do I do now? So a couple points I want to make on that. One is, I've made this before, is to maintain your record keeping. It's really important. In some situations, we've recommended that clients open up a separate account. Very important to make sure you know how all the money is spent out of that account from the Paycheck Protection Loan monies. At least 75% of those monies that you're asking forgiveness on have to be spent on payroll costs. The other up to 25% can be spent on rent, utilities, and mortgage interest. So it's really important to maintain copies of checks, copies of invoices, your payroll records. When you go to apply for forgiveness, you're gonna have to submit your 941s. So I think record keeping is a very important aspect of that. The second part of that is really, how are we gonna maximize our forgiveness amount? And that's a conversation I've been having with a lot of clients lately, looking at, and we've talked about this before, but looking at your FTE count during the 8-week covered period, as compared to the FTE count during the period of January, February this year, or the period from February 15th to June 30th of last year. One of the things to really consider in this is the timing of layoffs and the timing of bringing people back. It's really important to look at those people that may have been laid off between February 15th of this year and April 25th of this year, and when you're bringing those people back, or if you've had wage reductions in that time. That is going to impact. The lawnmower just went by, so hopefully that wasn't too loud. That's going to impact the amount of your loan forgiveness. And really there are a lot of things to look at. And I've got this analysis a number of times. One is your FTE counts during the covered period as compared to those the other two periods. The second is the layoffs that you've had earlier this year between February 15th and April 25th. And the requirement under the statute to fully restore those people and those FTEs by June 30th of this year. The third is looking at the FTE count that you lose or maybe you gain after April 26th and how that impacts your loan forgiveness. So there are lots of different layers that we have to look at that could impact your loan forgiveness. And the intent here, as we all know, is to bring back as many employees as possible, get as many employees back on your payroll, and really to maximize your loan forgiveness in that context. One of the questions that I know came up is, what if you have someone voluntarily resign, and maybe they've resigned already, or maybe they resign after April 25th. That, as far as we know today, that is still going to affect your percentages and your proportions when looking at the FTE calculation on your forgiveness. So it really doesn't matter why or how a person left as far as we know. It could have been retirement, but that could have an adverse effect on your loan forgiveness amount. The other question that I've had asked is that, some employees with the souped up unemployment payments now may be making more money or getting more money through their unemployment wages than they were getting when they were getting paid and may not want to come back to work. So, I think, again, the incentive there is to bring them back on your payroll. From my understanding, and I think Pete or Adam can confirm this, is if someone has already applied for unemployment, if they come back on your payroll, they just don't claim the unemployment during that period. But if they're laid off again after that period, they can go back and reclaim unemployment benefits after that period. So that could alleviate some concern that someone has of coming back to work once they're on unemployment.
That's right, Jeff. The claim can stay open, and you can report your weekly hours. And so people who are kind of on again, off again in a furlough situation, or perhaps relative to these programs, can get unemployment benefits in weeks in which they don't work. Great.
Thanks, Pete. So I think, really the point is, look at your numbers, look at your FTE counts, who's been laid off, when you're bringing people back, what wage reductions that there may have been in the meantime. I'm also getting lots of questions about what programs you can combine with the Paycheck Protection Program. And one of the things that we've been looking at is the fact that you can defer FICA so long as your paycheck protection loan is before it's forgiven, basically. So if you don't have the Paycheck Protection Loan Program, you can defer FICA for this year, and it's paid back over the course of the next 2 years. If you do have a paycheck protection loan, you can defer FICA up to the point in time when it's forgiven, and then it's paid back in accordance with that schedule. So the last thing I wanted to talk about is kind of where are we going from here? And I think everyone's been paying attention to the news and what the Senate's doing. There was some news right before we came back on this call about the Senate program and additional monies that are coming on board. So if you missed out on the Paycheck Protection Program, there's another, it looks like $310 billion that are coming into that program. 120 or 125 billion of that is going to be earmarked, from what I understand, to the underserved, to rural communities. Monies are going to be earmarked for community lenders. The quote that I read was, the little mom and pop stores that don't have a good banking connection are going to have access to these dollars. I'm not sure how that's going to work out, but that'll work out. Also, the Economic Injury Disaster Loan Program under the SBA will see an additional $60 billion from what I understand. And lastly, we're supposed to be seeing some additional guidance on the Main Street Lending Program, hopefully within the next few days, which is really earmarked towards our larger employers to get access to some of the dollars that are out there. So that's about all that I have for an update, and I'll put it back over to Pete.
Thanks, Jeff. We are slightly over our time. We've been trying to commit to keep this to 45 minutes, and so we're gonna try and do that. The fault lies with me. I have tried to encourage an ambitious agenda so we could get a lot of information out to everybody. Unfortunately, that leaves us with less time to answer questions. So what I'd like to do is encourage you to contact whoever you work with at Bond and ask those questions. I guess the thing that we're really focused on today is starting to think about what reopening might look like, so you'll be ahead of the game when that time does come. Thanks everyone for being on today. Be safe, and we'll talk to you next week.